The marble columns of the Supreme Court rose majestically as morning light filtered through the high windows. The highest court in the land was hearing arguments in Wilson versus Educational Opportunity Foundation, a complex case involving equal access to educational resources across different communities. Legal experts had anticipated a routine, if important, day of technical arguments about funding formulas and jurisdictional questions. Chief Justice John Roberts presided with his characteristic calm authority. At 70, the veteran jurist had heard thousands of oral arguments during his tenure on the court. His penetrating questions and precise legal mind had earned respect across the ideological spectrum, even from those who often disagreed with his conclusions. Representative Jasmine Crockett, a former civil rights attorney before entering Congress, had filed an amicus brief in the case and was granted time to present oral arguments. Though respected in legal circles, few expected her presentation to stand out among the many distinguished advocates appearing that day. What happened next left the entire courtroom in a moment of profound silence. As Crockett concluded her meticulously crafted argument about educational equity and constitutional principles, Chief Justice Roberts leaned forward slightly. Instead of moving immediately to questions as expected, he did something extraordinarily rare in the formal setting of the Supreme Court. "Representative Crockett," he began, his voice carrying clearly through the hushed chamber, "before we proceed to questions, I want to acknowledge something. In my years on this court, I have seldom encountered legal reasoning that so precisely weaves together constitutional principles, precedent, and practical realities. Your argument today represents legal advocacy at its finest." The sincerity in his voice was unmistakable. This wasn't perfunctory courtesy, but genuine professional respect, from the nation's highest judicial officer to an advocate whose legal brilliance transcended the usual political divides. The entire courtroom fell into a reverent silence that acknowledged the remarkable nature of this moment. Before we continue this extraordinary story, please take a moment to like this video and subscribe to our channel for more content that celebrates moments when legal excellence and professional respect rise above our partisan divisions. To understand why this moment between Chief Justice Roberts and Representative Crockett resonated so deeply in legal circles and beyond, it's important to appreciate the unique journeys and legal backgrounds of these two accomplished attorneys. John Roberts had followed a path of consistent legal excellence throughout his career. After graduating from Harvard Law School, where he served as managing editor of the Harvard Law Review, he clerked for then Associate Justice William Rehnquist. His subsequent career included distinguished service in the Department of Justice and private practice, where he argued 39 cases before the Supreme Court prior to his appointment to the bench. Nominated as Chief Justice in 2005, Roberts had developed a reputation for careful jurisprudence that respected precedent while remaining open to evolving legal understanding. Though generally conservative in his legal philosophy, he had occasionally surprised observers with decisions that crossed ideological lines when he believed constitutional principles required it. Legal scholars who studied Roberts' tenure noted his deep commitment to the integrity of the court as an institution above partisan politics. A former clerk once observed, "The chief believes profoundly in the role of the court as an impartial arbiter of constitutional principles rather than a vehicle for political preferences. That belief shapes everything about his approach to the law." Roberts was known for holding advocates to exacting standards during oral arguments, posing precise questions that tested the logical foundations of their positions. His respect was not easily earned, making his recognition of exceptional legal reasoning all the more significant when it occurred. Jasmine Crockett had traveled a different path to legal prominence. After graduating from law school, she had built her career representing clients from underserved communities in civil rights and educational access cases. Rather than the prestigious corporate firms that often serve as pipelines to judicial appointments, she had chosen to work directly with those most affected by systemic inequities in the legal system. This frontline experience had given Crockett an unusual perspective on how abstract legal principles translated into real impacts on communities and individuals. Her approach to constitutional interpretation was informed not just by theory, but by direct observation of how judicial decisions affected people's lives and opportunities. After establishing herself as a formidable civil rights attorney with several landmark cases to her credit, Crockett had successfully run for Congress, where she quickly distinguished herself through her substantive approach to legislation. Unlike many representatives with legal backgrounds who set aside deep legal analysis for political messaging, she continued to engage with complex legal questions, bringing her litigation experience to her legislative work. The Wilson case that brought Roberts and Crockett into the same courtroom centered on whether funding disparities between school districts violated constitutional equal protection guarantees. The case raised complex questions about the intersection of local control, federal authority, and fundamental rights, issues that had divided courts for decades. We'd love to hear in the comments section if you've ever witnessed a moment where professional excellence was recognized across usual dividing lines. These moments of genuine respect remind us that expertise and integrity can still transcend our political divisions. The Supreme Court that morning was filled with the usual array of justices, clerks, attorneys, journalists, and fortunate members of the public who had secured coveted seats. The atmosphere was one of formal attentiveness, with the court's traditional decorum creating a setting where legal arguments took center stage, separated from the more theatrical aspects of political discourse. What no one anticipated was that this session would produce a moment of professional recognition that would soon inspire discussions about legal excellence and respect across the entire legal community. The Supreme Court session had begun with the usual formalities: the marshal's announcement, the justices taking their seats, preliminary matters addressed efficiently before oral arguments began. The first attorney representing the petitioners had presented competent arguments about local control and traditional funding mechanisms, facing pointed questions from justices across the ideological spectrum. When Representative Crockett's turn came, those familiar with Supreme Court proceedings noticed subtle differences in her approach that immediately distinguished her presentation. Rather than beginning with abstract legal principles or political framing, she opened with a precise articulation of the constitutional question at hand. "Mr. Chief Justice, and may it please the Court," she began, "this case presents a fundamental question about how we interpret equal protection guarantees when educational opportunity, a cornerstone of meaningful citizenship in our republic, varies dramatically based on community resources and local tax bases." From this opening, Crockett moved into a methodical analysis that demonstrated unusual legal precision. Rather than arguing from broad principles alone, she wove together several strands of legal reasoning that built her case layer by layer. First, she traced the evolution of equal protection jurisprudence through key Supreme Court decisions, demonstrating how the court's understanding had developed over decades. Unlike many advocates who selectively cite favorable precedents while ignoring contrary ones, Crockett directly addressed cases that might seem to undermine her position, distinguishing them with nuanced analysis rather than dismissive characterizations. In San Antonio versus Rodriguez, this court held that education is not a fundamental right explicitly guaranteed by the Constitution, she acknowledged, referencing a case often cited against educational equity claims. However, the court's subsequent jurisprudence in Plyler v. Doe recognized education's unique importance in maintaining the fabric of our society and enabling meaningful participation in civic life. This direct engagement with challenging precedent caught the attention of several justices, who leaned forward slightly, the Supreme Court equivalent of showing keen interest. Crockett then moved to her second analytical strand, examining how the court's approach to equal protection had evolved beyond formal equality to recognize substantive dimensions of constitutional guarantees. She cited with precise specificity language from opinions written by justices across the ideological spectrum, demonstrating how this understanding had developed through diverse judicial perspectives. Justice Elena Kagan posed the first question, probing the boundaries of Crockett's legal theory. "Counselor, if we accept your framework for analyzing these educational disparities, what limiting principle would prevent similar claims regarding other public services where local funding creates disparities?" It was the kind of challenging question that often disrupts an advocate's presentation, forcing them to either concede weaknesses in their position or retreat to vaguer principles. Crockett's response, however, demonstrated the depth of her legal thinking. Justice Kagan, the limiting principle emerges from this court's consistent recognition of education's unique position in enabling meaningful exercise of other constitutional rights and civic participation, she began. She then articulated a three-part test derived from the court's own precedents that would distinguish educational equity claims from those involving other public services, providing a practical framework for judicial analysis that respected separation of powers concerns. Justice Samuel Alito followed with a question from a different perspective. Your argument seems to require significant judicial oversight of local educational funding decisions. How do you reconcile this with our federalism principles and tradition of local control in education? Again, Crockett's response reflected deep legal understanding rather than ideological positioning. Justice Alito, federalism serves constitutional values by protecting both state authority and fundamental national rights. The framework I'm proposing respects local control for most educational decisions, while recognizing that extreme disparities that undermine equal protection guarantees properly invoke federal judicial review. She continued by citing specific examples from states where local control coexisted with constitutional equity guarantees, demonstrating that her position built upon rather than discarded federalism principles. This nuanced response, acknowledging legitimate concerns while providing substantive answers, clearly impressed even justices likely to be skeptical of her ultimate conclusions. As her argument continued, Crockett introduced her third analytical strand, empirical evidence connecting educational resources to meaningful outcomes. Unlike many advocates who rely on generalized assertions about policy impacts, she presented specific research findings with methodological context that anticipated potential criticisms. The empirical evidence confirms what this court recognized in Brown v. Board of Education, that education is a right which must be made available to all on equal terms, if equal protection guarantees are to have substance rather than mere form. Recent longitudinal studies using causal research designs demonstrate that systematic resource disparities create precisely the kind of arbitrary disadvantage based on circumstances of birth that the Equal Protection Clause was designed to prevent. Chief Justice Roberts, who had been listening intently throughout, posed what many considered the most challenging question. Representative Crockett, your argument requires us to make comparative judgments about educational adequacy across different contexts. Doesn't this inevitably draw courts into educational policy decisions, better left to legislative bodies? This question went to the heart of the separation of powers concerns that often guide Roberts' jurisprudence. The courtroom grew especially attentive, recognizing this as a potential turning point in the argument. Crockett's response demonstrated both deep respect for the court's institutional role and precise understanding of constitutional principles. Mr. Chief Justice, the approach I'm advocating recognizes the primary role of legislative bodies in educational policy, while preserving the judiciary's essential function in enforcing constitutional guarantees. She continued with remarkable specificity. The test I've outlined would not require courts to make policy determinations about optimal educational methods or specific funding levels. Rather, it would examine whether disparities are so severe that they effectively deny some children the basic educational opportunity that enables meaningful exercise of other constitutional rights and civic participation. Crockett then connected this framework to the court's own institutional history. This approach builds upon this court's long-standing practice of identifying constitutional floors without mandating policy ceilings, preserving legislative discretion while enforcing fundamental guarantees. Throughout her presentation, what distinguished Crockett's advocacy was her ability to engage with challenging questions as opportunities for deeper analysis rather than obstacles to avoid. Each response built upon her core legal framework while demonstrating respect for legitimate institutional concerns raised by the justices. As she concluded her formal argument, Crockett returned to first principles. The Constitution's promise of equal protection requires that where states choose to provide education, which all 50 do, they cannot do so in ways that systematically advantage some children and disadvantage others based merely on the arbitrary circumstance of which local community they live in. This court has the constitutional authority and responsibility to enforce that guarantee while respecting the proper role of legislative bodies in shaping specific policies. Her final words reflected both conviction about constitutional principles and respect for the court's institutional role. The framework I've presented offers a path for the court to fulfill its essential function as guardian of constitutional guarantees while preserving appropriate deference to legislative judgments about educational policy. It is rooted in this court's own jurisprudence, respectful of federalism principles, and faithful to the Constitution's fundamental promise of equal protection under law. As Crockett finished, the courtroom remained in that rare state of complete attention that signals exceptional advocacy. Even attorneys waiting for later cases, who often use oral arguments to prepare their own presentations, had set aside their notes to follow her analysis. It was at this moment that Chief Justice Roberts, instead of moving immediately to the next scheduled presenter, offered his unprecedented acknowledgement of her legal brilliance, a moment of genuine professional respect that transcended the political divisions typically associated with educational equity cases. Representative Crockett, Chief Justice Roberts began. Before we proceed to questions, I want to acknowledge something. In my years on this court, I have seldom encountered legal reasoning that so precisely weaves together constitutional principles, precedent, and practical realities. Your argument today represents legal advocacy at its finest. The courtroom fell silent. Those familiar with Supreme Court proceedings understood how extraordinary this moment was. While justices occasionally praise particularly effective advocacy, such recognition from the Chief Justice, especially one as measured and precise as Roberts, represented the highest form of professional respect in the legal community. Roberts continued, his tone reflecting genuine professional appreciation rather than perfunctory courtesy. Your ability to anticipate and substantively address institutional concerns while maintaining a coherent constitutional framework demonstrates the kind of rigorous legal thinking that assists this court in its deliberations, regardless of where individual justices may ultimately come down on the merits. This wasn't empty praise, but specific recognition of the qualities that distinguish truly exceptional legal advocacy: anticipating concerns, addressing them substantively, and maintaining analytical coherence throughout. It was praise for intellectual integrity and legal craft, not for reaching a particular conclusion. Justice Sonia Sotomayor, who had yet to ask a question, nodded in visible agreement with Roberts's assessment. Though often at opposite ends of judicial philosophy from the Chief Justice, she recognized, as he did, the exceptional quality of Crockett's legal reasoning. Roberts concluded his unexpected comments with an observation that captured why this moment would soon resonate throughout the legal community. Advocacy of this caliber elevates our entire legal system by demonstrating how principled reasoning can address even the most complex and contested constitutional questions. It reminds us that, at its best, legal argument is not about political positions, but about faithful interpretation of constitutional principles. The silence that followed wasn't the awkward pause of surprised confusion, but the reverent quiet of collective recognition, an acknowledgement that those present had witnessed something exceptional in the life of the court. Journalists present, even those who typically emphasize political divisions on the court, recognized that this moment transcended usual ideological narratives about Supreme Court proceedings. As the silence stretched for several seconds, Crockett responded with professional grace that matched the moment. "Thank you, Mr. Chief Justice. The opportunity to present complex constitutional questions to this court is the highest privilege of our profession. I'm deeply honored by your words." The exchange, brief but profound, captured something essential about legal excellence that often gets lost in political coverage of the court. Beyond ideological differences and policy disagreements, there exists a shared appreciation among legal professionals for exceptional analytical reasoning and principled advocacy. Justice Stephen Breyer, known for his practical approach to constitutional questions, then posed a follow-up question that moved the proceedings forward while maintaining the tone of substantive engagement. Building on your framework, Representative Crockett, how would you have us articulate the standard for determining when educational disparities cross the constitutional threshold? This question, seeking elaboration rather than challenging fundamental premises, reflected how Crockett's exceptional advocacy had shifted the discussion from whether her framework had merit to how it might be practically applied. It represented a level of engagement typically reserved for arguments that justices find particularly compelling, regardless of their predispositions on the underlying issues. Crockett's response continued to demonstrate the qualities Roberts had recognized. Justice Breyer, I would propose articulating the standard in terms of whether disparities effectively foreclose the basic educational opportunity necessary for meaningful exercise of other constitutional rights and civic participation. This would require examining both resource inputs and outcome measures through a functional rather than formalistic lens. She then outlined specific workable criteria courts could use to apply this standard without becoming entangled in policy judgments better left to legislative bodies. Her approach acknowledged legitimate concerns about judicial overreach while providing principled guidance for enforcing constitutional guarantees. Exactly the kind of balanced analysis that earns respect across ideological lines in the legal community. As the questioning continued, justices from across the court's ideological spectrum engaged with Crockett's framework, not necessarily indicating agreement with her conclusions, but demonstrating respect for the intellectual integrity of her analysis. Questions probed boundaries, tested implications, and explored practical applications. The kind of substantive engagement that signals an argument is being taken seriously on its merits. Throughout this extended questioning, Crockett maintained the exceptional quality of her advocacy. Rather than becoming defensive when challenged or triumphant when receiving supportive questions, she engaged each inquiry with the same analytical rigor and respect for the court's institutional role. This consistent excellence further confirmed Roberts's assessment of her advocacy. As her time concluded and the next attorney was called, something unusual happened. Several justices, including some likely to disagree with Crockett's position on the merits, made notes on her argument, not merely to reference points they wished to address later, but to capture aspects of her analytical framework that had impressed them regardless of their predispositions on the case. In the press section, journalists who had come expecting typical ideological divisions found themselves documenting something different, a moment where professional excellence had been recognized across those divisions, reminding observers that beneath political narratives about the court lies a legal institution where craft and reasoning still matter tremendously. What neither Roberts nor Crockett could have anticipated was how quickly word of this exchange would spread through legal circles and beyond, inspiring discussions about excellence in legal reasoning and the capacity for professional respect to transcend political divisions. In the days following the Supreme Court argument, something remarkable began happening throughout the legal community. What might have been just another day of oral arguments was transformed by Roberts's recognition of Crockett's legal brilliance into a moment that inspired reflection about excellence in legal reasoning and professional respect across ideological lines. The court's official transcript and audio recording were released per standard procedure, but what wasn't standard was how widely they circulated. Law professors from schools across the ideological spectrum shared the exchange with their students, not as an example of particular legal conclusions, but as a demonstration of exceptional advocacy that transcended political positions. In my 30 years teaching constitutional law, I've rarely used Supreme Court arguments as teaching tools, noted a professor at a leading law school. But Crockett's presentation and Roberts' recognition of its excellence offer something invaluable for aspiring lawyers to study, regardless of their political leanings or views on the specific case. Law firms similarly incorporated the argument into professional development programs. A senior partner at a major firm explained, "What makes this exchange so valuable isn't that either Crockett or Roberts reached particular conclusions. It's that it demonstrates what truly excellent legal reasoning looks like, anticipating concerns, engaging with challenging precedent, building coherent analytical frameworks. These skills transcend political positions and represent the highest aspirations of our profession." The impact extended beyond training future lawyers. Judicial conferences and bar associations across the country incorporated discussions of the exchange into programs about excellence in advocacy. These discussions emphasized how Crockett's presentation demonstrated key qualities that enhanced the judicial process itself: precision in framing legal questions, substantive engagement with challenging precedent, and respect for institutional roles while advocating for principled positions. For Roberts and Crockett themselves, the public response to their exchange was both affirming and somewhat surprising. Roberts, when asked about his comments at a judicial conference weeks later, offered a characteristically measured reflection. The court functions best when presented with the strongest possible legal reasoning from advocates across the spectrum of constitutional viewpoints. Recognition of exceptional advocacy isn't about agreement with particular conclusions. It's about appreciation for the kind of rigorous analysis that helps the court fulfill its constitutional function. Crockett, speaking to law students at her alma mater, similarly emphasized the substance behind the exchange rather than its personal dimensions. What matters isn't that my particular argument received recognition, but that there remains space in our legal system for substantive engagement across different judicial philosophies and political perspectives. The law at its best has always involved this kind of engagement, with ideas rather than merely with political positions. The most significant impact came in how the exchange influenced discussions about the relationship between law and politics in American society. In an era when Supreme Court coverage often focused primarily on political dimensions, this moment offered a powerful reminder that beneath those dimensions lies a legal institution where craft, reasoning, and principled analysis still command respect across ideological lines. Legal commentators who typically emphasize political narratives found themselves discussing different aspects of the court's functioning. One noted constitutional scholar observed, "What makes the Roberts-Crockett exchange so significant isn't just professional courtesy between two accomplished attorneys. It's a window into how the court at its best functions not as a political body, but as a legal institution where rigorous reasoning and principled analysis command respect, regardless of ideological alignment." 6 months after the argument, as the legal community awaited the court's decision in Wilson, law schools across the country hosted a coordinated series of programs examining excellence in legal reasoning across divides. These events brought together judges, practitioners, and scholars from different jurisprudential perspectives to discuss how Crockett's advocacy exemplified qualities that enhance legal discourse regardless of specific conclusions. "What Representative Crockett demonstrated in her argument," noted a federal judge speaking at one such event, "wasn't advocacy that would appeal only to those already aligned with her position. It was advocacy that commanded respect from those with very different perspectives because it engaged substantively with their concerns, rather than dismissing or avoiding them. This emphasis on substantive engagement, rather than mere persuasion of the already convinced, reflected a deeper understanding of advocacy's role in a constitutional system. As a distinguished appellate attorney observed during another program, the highest form of advocacy isn't about scoring points or appealing to those who already share your conclusions. It's about advancing understanding of constitutional principles and their applications through rigorous reasoning that respects different perspectives while maintaining principled positions." Law clerks from that Supreme Court term, speaking later with appropriate discretion, noted how the exchange had influenced discussions among the justices during their deliberations. Without revealing confidential details about the court's internal processes, several mentioned that Crockett's analytical framework became a significant reference point in their discussions, cited by justices across the ideological spectrum, even when they disagreed about ultimate conclusions. When the court eventually issued its decision in Wilson, legal observers noted something unusual. Though the justices divided on aspects of the holding, as expected given their different judicial philosophies, the opinion contained sections of analytical common ground that built upon frameworks Crockett had presented. This suggested her advocacy had influenced the court's thinking in ways that transcended usual ideological divisions. Chief Justice Roberts' majority opinion specifically noted, "While members of this court may reach different conclusions about specific applications of equal protection principles to educational funding, we acknowledge the exceptionally thoughtful framework presented during oral argument that helped clarify the constitutional questions at stake." This citation, unusual in its specific acknowledgement of advocacy's contribution to the court's analysis, further confirmed the exceptional nature of Crockett's legal reasoning and its impact on the court's deliberative process. Perhaps the most lasting legacy came in how law schools incorporated the Roberts-Crockett exchange into their teaching about legal advocacy. Rather than focusing exclusively on winning arguments or persuasive techniques, professors began emphasizing how truly excellent advocacy enhances the judicial process itself through rigorous reasoning and substantive engagement with different perspectives. A year after the argument, a consortium of law schools announced the creation of the Excellence in Constitutional Advocacy program, designed to train future lawyers in the qualities Crockett had demonstrated: precision in legal reasoning, substantive engagement with challenging precedent, respect for institutional roles, and principled analysis that commanded respect across jurisprudential divides. When asked to speak at the program's launch, Crockett emphasized that excellence in advocacy served constitutional values beyond any particular case outcome. The constitutional system functions best when courts engage with the strongest possible arguments from different perspectives. Advocacy that facilitates this engagement, that anticipates concerns, addresses them substantively, and maintains analytical coherence, strengthens our constitutional democracy regardless of specific case outcomes. Roberts, though declining formal involvement to maintain appropriate judicial distance, sent a message to program participants that reflected similar values. The quality of advocacy directly affects the quality of judicial decision-making. When advocates present rigorous, principled analysis that engages substantively with different perspectives, they help courts fulfill their constitutional function more effectively. The story of Roberts' recognition of Crockett's legal brilliance serves as a powerful reminder that beneath political narratives about our legal institutions lies a professional community where excellence in reasoning and principled analysis can still command respect across ideological lines. Their exchange demonstrated how substantive engagement across differences strengthens not just individual cases, but the constitutional system itself. As we conclude this remarkable story, we invite you to like and subscribe for more content that celebrates moments of excellence and respect in American institutions. In a media landscape that often emphasizes division, we're committed to highlighting examples of how professional integrity and intellectual rigor can still transcend those divisions. America's legal challenges remain complex, and perspectives on constitutional interpretation vary significantly. But the Roberts-Crockett exchange reminds us that addressing these challenges effectively requires not just advocacy for particular positions, but the kind of rigorous reasoning and substantive engagement that enhances our entire constitutional system. In your own professional life, consider how you might apply the lessons from this powerful moment. How might you advance your principles and perspectives while engaging substantively with different viewpoints? The health of our democracy depends on professionals in all fields who can combine strong convictions with the kind of intellectual integrity and respect that Roberts and Crockett demonstrated in their remarkable exchange.